Okay. And now we are live and I'm gonna share. Okay, and there you go. Go ahead, B.
Which of the following arguments would be most helpful to the state in defending the constitutionality of the law? So most helpful to the state. I know that I'm in constitutional law. So I'm gonna just go right into the answers. Or I see this little sentence, I'm gonna read it. In response to these complaints, the legislature enacted a law prohibiting medical care providers from soliciting any accident victims by telephone within 30 days of his or her accident. Okay, so now I'm going to go, which of the following arguments would be most helpful to the state in defending the constitutionality of the law? A, because the commercial speech that is the subject of the law includes some speech that is misleading, the First Amendment does not limit the state's power to regulate that speech. Okay, let me start over. A, because the commercial speech that is the subject of the law, so commercial speech, includes some speech that is misleading, the First Amendment does not limit the state's power to regulate that speech. The state's power does not limit. You can regulate commercial speech. So I'm going to leave A. B, because
you just tell me you can regulate it.
The First
but
Amendment.
This here say does not limit.
Okay, so then it's out. I'm scratching it. I thought I'm overthinking it. So it's definitely out. It's not a true statement. B, because the law regulates only commercial speech, the state need only demonstrate that the restriction is rationally related to achieving the state's legitimate interest in protecting the privacy of accident victims in regulating the medical profession. So rationally related and a legitimate interest, and that's the bottom scrutiny, which is rational scrutiny. And because the law regulates only commercial speech. I'm going to read B again. B, because the law regulates only commercial speech, the state need only demonstrate that the restriction is rationally related to achieving the state's legitimate interest in protecting the privacy of accident victims and in regulating the medical profession. I mean, I think that's a true statement. Rationally related to a legitimate interest. I'm going to leave B. I'm not sure if I should strike it, but I'm going to read C. I think I like B. C, the state has substantial interest in protecting the privacy of accident victims and in regulating the practice of medical care providers, and the law is narrowly tailored to achieve the state's objective. Okay, so it's privacy then. And I think privacy is, if I'm not mistaken, is strict scrutiny. If I remember correctly, I don't know. So this is a substantial interest is with the highest scrutiny, which is, oh my God, rational, intermediate, and the heightened scrutiny. Okay, I don't know. I'm leaving C. D, the law is a reasonable time and place manner regulation. That's for commercial speech, I believe. Oh, I don't remember the law, Mr. V. I'm going to read the facts. I'm going to leave those three because this is the low scrutiny, high scrutiny, and this is time and place and manner, which is also okay. A state legislature received complaints from traffic accident victims who, in the days immediately following their accident, had received unwelcome and occasionally misleading telephone calls on behalf of medical care providers. The callers warned of the risk of not obtaining prompt medical evaluation to detect injuries resulting from accidents and offered free examinations to determine whether the victims had suffered any compensable injuries. In response to these complaints, the legislature enacted a law prohibiting medical care providers from soliciting any accident victim by telephone within 30 days of his or her accident. Which of the following arguments would be most helpful to the state in defending the constitutionality of the law? I don't know. I'm going to read B again. B, because the law regulates only commercial speech. It's not really regulating commercial speech. It's telling them when they can call. Commercial speech, the state need only demonstrate that the restriction is rationally related to achieve a state's legitimate interest in protecting the privacy of accident victims and in regulating. Okay, this is wrong because the burden's not on the state. So I'm scratching B. The state has substantial interest in protecting the privacy of accident victims and in regulating the practice of medical care providers, and the law is narrowly tailored to achieve the state's objective. I'm going to go with D because they're regulating they're regulating the time and the place, like within the 30 days of the accident. And I don't think it triggers any of the heightened scrutinies unless it's privacy. D is my answer, Mr. V. I strike this.
Okay.
Oh.
All right. Well, first, after we Zoom, you guys need to learn the 3 level. Go back and review that. Okay, that's one of your assignment. Okay, so here we go. Because your guys are not confident yet, so please go back and review the charts. Okay, so Courtney, B is correct. Would be say most helpful, right? Most helpful to the state. Okay. So circle most helpful. A, because commercial speech is subject to the law, includes some speech that is misleading. Okay. Well, your guy forgot. Because any commercial law, any commercial speech cannot be misleading. Cannot be, because that would be fraud. Because the commercial speech that is subject to the law includes some speech that is, see it? So this sentence is wrong. So cannot be misleading. And then the next sentence say, the First Amendment does not limit the state's power to regulate that speech. Well, are you telling me that the state power can regulate the speech any day want? There's no limit? You know, that's overbroad, remember? So that's also wrong. So A is gone. Okay. They gave you the big hint, but you guys not master the law yet, because this is the The first question, misleading and not limit. Okay, everything is limit. Everything is reasonable. But you don't want somebody no limit. They can do whatever they want. That would be too much. B, because the state law regulate only commercial speech, the state need to not, the state need only demonstrate, the state need only demonstrate that the restriction is rational. Right here is another clue. If it's rational, then the petitioner have to prove it. So therefore it's wrong. Okay, if it's rational, it go with the applicant, the people, not the state. The only thing the state need to do is when it's the middle part, quasi-strict, and then strict scrutiny. So B is out. Okay. C, the state has substantial interest in protect the privacy accident victim. And why do they have an interest to protecting the privacy of a victim? Because if you look at the fact, it bothered the people of the victim and regulate the practice medical provider. That law is narrowly tailored. See, it gotta be narrowly tailored to achieve the state objective. So the word narrowly tailored is strict scrutiny. You see, so a freedom of speech, that's your First Amendment. All the First Amendment are strict scrutiny, all your First Amendment. So narrowly tailored, see it, and it had to get to the state objective. So First Amendment speech is a First Amendment, and everything belongs to First Amendment is strict. So this makes sense. Now, the worst thing that your guy don't get it, you got to pick the law is rational time, place, and manner regulation. You got to forget again. They gave you 3 of them, like who has the burden of proof, what level it is, right? They gave you 3 answers talking about those kind of things, right? Who has the burden of proof, what level it is, and then you pick time, place, and manner. See it? They're going to test you time, place, and manner, something else. Why do they spend so much time and telling you who had the burden of proofs, misleading, da, 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 da. So not only you read the answer first, try to strike, but also read the answer to accumulate all 4 together. And what is the most thing they talking about? That's the subject matter they're going to test you on, right? And then again, this sucker had the law, okay? This is the law, time, place, and manner had the law, but it doesn't have the analysis of it. It doesn't have the analysis. C have law and analysis.
I'm guessing it's C. C, correct. The law regulates only commercial speech, and the First Amendment invalidates any law regulating such speech unless the law is narrowly tailored to serve a substantial government interest. The U.S. Supreme Court has held that a law barring the solicitation of accident victims within a limited time period following an accident was narrowly tailored to serve the state's substantial interest in protecting the privacy of the victims. Okay.
So today lessons that is not talk about other lessons. Today's lesson is we try to find the subject matter before we read the answer. But the bar examiner also get us the subject matter when you plus and minus all three together. When you put A, B, C, D in a pot, it will tell you what subject matter you're on. And from that, you can eliminate things like this one. You see it? But here, the bar examiner on, especially on common law, if you know the definitions and if you know the thing, you can strike a lot of them. You can strike a lot of them. See? Okay. Any question before we stop?
No.
Pretty good?
Yes.
Okay. So review the 3 levels strict scrutiny and the languages that attach to which one, and also who has the burden of proof.